The processes and procedures for challenging the application for probate are as follows. And please note, I'm trying to take this in order of sequence. Having talked about who can challenge application for probate, I've also talked about who can challenge the validity of a will. So next, let me take you through the process of challenging an application for process. When I have done this, I will then talk about the process for challenging the validity of a will. The first step you take to challenge the validity, to challenge an application for probate is to file a caveat at the probate registry. This freezes the application for the time being. This is actually the issuance of a warning. Then the probate will issue a warning to the persons who had applied for probate. And then they will be required to enter an appearance and thereafter defend their position. And you too will be expected to defend your position. The summons for directions will be issued. A judge will set directions for resolving the dispute. And then there is hearing of evidence. And then judgment is given. This procedure is governed by the High Court rules and the rules must be complied with strictly with evidentiary requirements met. Next, there is a process for challenging the validity of a will. And this may happen before or after the grant of probate. The challenger would normally file a probate suit at the High Court. Usually when this action is filed, it's usually contentious, requiring evidence to be led on both sides. And the grounds upon which you challenge would actually include mental incapacity or undue influence or other legal grounds for challenging the validity of a will. The court will determine whether the will was duly executed and valid. Depending on the outcome, the will may be admitted to probate or declared invalid, resulting in intestacy. Let me explain. When the challenge to the will succeeds, the will is declared invalid, and this may result in intestacy. Where it fails, the will is upheld and is executed. The grounds for challenging an application for probate usually will include that the applicant is not named as an executor, or that the will is forged or invalid, or that the deceased was coerced,